You may be seated. We're waiting for one more juror to approach. All right, good afternoon. This is the case of the Estate of Peter Jones versus Dragon Studios. Could we have appearances for counsel?
Yes, Your Honor, starting with the plaintiff.
Whenever you're ready, yes.
Good afternoon, Your Honor. My name is Josiah Jones, and today I'm joined by my co-counsel, Mr. Dylan Darvish.
Afternoon, Your Honor.
Together, we represent the plaintiff in this trial, the Jones family.
All right, thank you very much for defense.
Yes, Your Honor. Good afternoon. My name is Lyla Zedell, and I'm here at counsel table with Ms. Maya Iyer. Good afternoon. And together we represent Dragon Studios Incorporated.
All right, thank you very much, counsel. Are there any matters that should be addressed by the court before we begin with witnesses and statements?
Yes, Your Honor, just a couple of things. First, prior to trial, me and opposing counsel actually met and agreed to pre-admit certain exhibits in this case. Those exhibits are exhibits 1 through 25.
All right.
And we'd ask your permission to be able to use some of those exhibits in opening statements as they become necessary.
That's fine.
Next, Your Honor.
That's fine with us, Your Honor.
All right, thank you.
Next, Your Honor, we'd like to invoke Rules 603 and 615, constructively swearing in and sequestering the witnesses who are going to testify today. Specifically, we don't have a party representative today.
All right, counsel.
Neither do we, Your Honor, so we're fine with those being invoked.
All right, so that will be the case.
Lastly, Your Honor, Exhibits 1 and 2 are videos that may come up throughout the course of trial. So Mr. Darwish is going to have a laptop here that we might use throughout the course of trial. Just wanted Your Honor to be aware of that.
All right, thank you very much. Counsel, any problem with that?
No problem with that.
All right, anything for the defense before we begin opening statements?
Yes, Your Honor, just a few things. Like Mr. Jones just said, Exhibits 1 through 25 are pre-admitted. So we've prepared a binder for the convenience of the members of the jury with those pre-admitted, pre-marked exhibits so that they can follow along as they come up during trial. Would it be all right if Ms. Iyer brought that to the jury right now?
Counsel?
No objections with that, Your Honor. They're in evidence.
All right, and I assume those are the same binders that I see in the witness stand and that I have in front of me?
Not quite, Your Honor. Those ones are the pre-admitted exhibits. The witnesses have access to other exhibits that may be entered throughout the course of trial.
All right.
That's our understanding, Your Honor. We wouldn't want to give the jury anything that wasn't already in evidence, so that's just 1 through 25.
All right, very good, thank you. Anything else?
Just one last thing, because we've never had the pleasure of serving in your court. I'd just like to ask your preferences for us moving about the well. Do you want us to ask permission before approaching witnesses in the bench?
If you keep a respectful distance from the witness, you don't need to ask permission. If you actually want to hover and point something out in a binder, I would like you to ask permission before you do that.
Absolutely, Your Honor.
Certainly, Your Honor.
And just one more thing. We'd like to direct the court's attention to the verdict forms. They're going to be in that binder in front of you. You'll see there's quite a few of them. We'd just like to make note that we'll be operating under verdict form C for the purposes of this specific trial.
All right, and just for purposes of the record, the verdict form C does what?
Your Honor, all this does is it states that the defense is electing to pursue an affirmative defense, specifically one of comparative fault.
And also contesting liability?
That's right, Your Honor.
All right. And plaintiff is?
That's our understanding as well, Your Honor.
All right, very well. Anything further before opening statements?
Defense is ready to go.
As we are. As are we, Your Honor.
All right, it's your opportunity to go first.
Yes, Your Honor. May I proceed?
Please.
May it please the court. Their decisions made that day different. It's June 21st, 2023. Peter Jones is falling. He's 2,700 feet in the air. He's not worried. You see, all day he's been practicing this stunt. He's been practicing stunts like this. He's been practicing to make sure this stunt he's doing is safe. He's a movie star. He's working on a set. He's got a team behind him that he trusts. So like those other practice runs, he's expecting that the director of this defendant company's studio, she's going to call him seconds into that dive to tell him, hey, release your parachute. What he doesn't know is that this director wants to make that shot as long as she possibly can. What he doesn't know is that when he finally makes the decision on his own to pull that chute, it's too late. Mr. Jones died that day. He died because their decisions made that day different. That's why we're here. That's why we, the plaintiff, on behalf of Mr. Jones's family, are suing this defendant company, Dragon Studios, for negligence. If you've ever seen any kind of legal drama, you might have heard the term proof beyond a reasonable doubt. Members of the jury, our burden today, it isn't that high. Instead, it's something called a preponderance of the evidence. Just more likely than not. That means today, if you decide that this defendant company breached their duty of care to Mr. Jones by failing to give him that signal, by leaving him up there alone, you have to find them liable. It's exactly what we're going to prove to you today. By asking you to focus on 3 critical decisions that made that day, June 21st, different from all the rest. They changed the stunt. They changed the staff. And they changed the signal. So let's take those one at a time, starting with how they changed the stunt. Because today you're going to find out that Mr. Jones, he had agreed to a plan for what that stunt was going to do. He was going to be in the air for 4 seconds, and then he was going to get that call. But on this particular day, June 21st, this defendant company, they made sure he was in the air for longer. They made sure he stayed up there much longer than he was originally supposed to. They doubled the amount of time that he was in the air. You're going to learn that that decision was dangerous. It's going to take us to decision number 2. Changing the staff. So you're going to learn that on June 20th, when Mr. Jones was able to successfully practice this stunt, he had a full team of staff behind him. People to help him hook in his harness, people on the ground watching, monitoring where he's at in the air, people in the control room, a stunt coordinator giving instructions on what's safe. But on June 21st, you're going to find out that this defendant company, they had a fraction of that staff. You're going to learn that that stunt coordinator who made sure it was safe, she wasn't there. That decision to operate with that staff, you're going to learn that that was a dangerous decision. It's going to take us to the third one. Not giving him his signal. Because today you're going to find out that on June 20th, when he was successful doing these practice dives, he had gotten the signal from this company over and over again. But a witness is going to take this stand today who was actually in the control room with the director of this studio, waiting for him to give Mr. Jones his signal. That witness is going to tell you that while he was there, they never gave him that signal. You're going to learn why. You're going to learn that it was because they wanted to make that shot as long as they could. You're going to learn that that signal, not giving it to Mr. Jones on that day, was a dangerous decision. Members of the jury, this case, it's going to come down to one critical question. What made that day, June 21st, different from all the rest? And what you're going to find out is the answer to that question is this defendant's decisions. Their decision to change the stunt. Their decision to change the staff. And their decision not to give Mr. Jones his signal. Going to learn that those were dangerous decisions. Because of that, he's no longer here with us today. That's why at the end of this trial, I'll stand before you again, and I'll ask that you find this defendant liable for negligence. Thank you for your time.
Defense, do you want to give your opening statement now?
Yes, Your Honor, may I proceed?
Yes, please proceed.
Your Honor, Mr. Jones, members of the jury, may it please the court. Peter Jones was pulling the strings. We know him as Harper, Travis Harper, an American James Bond super spy who makes any mission that looks impossible possible. Harper hangs from mountains 5,000 feet in the air, rappels down the tallest building in the world. He jumps off motorcycles into the midair. Travis Harper was the kind of character who didn't do anything halfway. 6 movies, $5 billion in revenue, all because the actor playing him, Peter Jones, was the person pulling the strings. It's a lot of pressure. Pressure from a talent agency, a production studio, pressure from millions of fans around the world. And Peter Jones, you'll learn, he felt the weight of that pressure on June 21st, 2023, when he made a tragic, reckless decision that unfortunately cost him his life. You'll learn today it wasn't actually Dragon Studios' decisions that made the difference, but Peter Jones's own negligent decision of when he was going to pull the strings of his parachute today. That's what made the difference. That's what killed him. It's why we've raised something called affirmative defense and assumed our own burden of proof. At the end of this trial, the judge is going to talk to you about something called comparative negligence. He'll explain that regardless of whether or not you think that Dragon Studios played a role in this tragedy, if you also think that Peter Jones's own negligent choices are what caused his death, well, then you have to find my client not liable. Today, the evidence will show that there was nothing that Dragon Studios could have or would have done differently. Because at the end of the day, members of the jury, they weren't the ones in the parachute. Peter Jones was pulling the strings, and he pulled them too late. You're going to learn throughout today's trial that there are 3 important choices to keep in mind. 3 choices that Peter Jones made, and Peter Jones made alone. 1, he chose the stunt. 2, he chose not to use a stunt double. And 3, Peter Jones chose not to pull the strings of his parachute when he was instructed to do so. Today you're going to learn that after he got that signal, well, he waited a few extra seconds. He waited a few extra seconds before pulling those strings, and you're going to learn that those few extra seconds are what cost him his life. You'll see today that June 21st, 2023 was not the first time Peter Jones was making decisions like these. I mean, we've all seen the movies. He performs extremely dangerous stunts in every one. Every single one being more and more dangerous than the last. We expect that you'll actually get to hear from Peter Jones' talent agent in court today, and she'll agree. He insisted. He insisted that he would do all the stunts himself because why? He was pulling the strings. So if he's done these stunts before, well then what made June 21st, 2023 any different? To answer that, we'll be calling the owner of Dragon Studios, Cole Doig, to the stand today. And he's going to tell you they did everything right. He'll tell you about the safety plans they had in place to make sure that Peter Jones would land safely. We'll show you the calculations, the careful calculations that the company made, the practices, the plans, everything they did to make sure that he would be able to land from that parachute safely. Mr. Doig will be the first to admit it was his responsibility to give the signal that day, and you're going to learn that that's exactly what he did. You see, my client had the right plan. They made safe decisions, but at the end of the day, it wasn't Mr. Doig wearing the parachute. Peter Jones, and Peter Jones alone, was the person pulling those strings. That's why he's no longer with us. At the end of the day, you'll see that this trial comes down to a man who was passionate about his work. Someone who would do anything for their audience. It'll come down to someone who pushed himself a little too far. The evidence will make it clear that it was Peter Jones and Peter Jones alone pulling the strings that day. So in a little while, I'm going to stand right here and ask that you find Dragon Studios not liable for negligence. Thank you for your time.
Thank you, counsel. Plaintiff, would you like to call your first witness?
Yes, Your Honor. We call Eli Gogolian. May I proceed?
Please.
Good afternoon, ma'am. Would you please introduce yourself to the members of our jury?
Hi, my name is Eli Gogion.
What do you do for a living, ma'am?
Well, I'm an agent. I represent actors and actresses in all the films that they do.
How'd you get into that line of work?
Well, you see, when I was a kid, I loved movies, but I found out pretty quickly that I couldn't act. So you know what they say, if you can't act, then if you can't do it, then teach. So that's what I did. I became an agent, and I started representing the people that could act.
Ma'am, do you know why it is that you're here in court today?
I do. You see, I was Peter Jones's agent on the day that he died on set filming that stunt.
Ma'am, I want to talk about who might have been responsible for Mr. Jones's death. You said he died doing his job. Do you know who he was working for at the time that he passed away?
I do. At that time, we were working with a production company called Dragon Studios.
What were you doing?
Well, we were preparing for that movie, and, we were planning for that stunt that Peter was supposed to do on set.
Who was the director of the film you were planning to shoot?
Well, there was this one man, he was the owner of that company, the CEO, and basically, his name was Cole Doig, and he was the one who helped us prepare.
And you just mentioned a stunt that Peter was planning to do. Do you think if I showed you a video, you'd be able to explain that stunt to the members of the jury?
Sure. I was there on set when we filmed.
Your Honor, permission to approach the witness with Exhibit 1, that pre-admitted video we discussed?
Yes.
All right, ma'am, I'm just going to set you up here. Can you see that okay?
Yes, sir, I can.
Before we go ahead and hit play, I want you to can you describe for the members of the jury what it is this film is from?
Yes, this is, this one's from our first day of filming. On June 20th, that was the first time we ever did that stunt. That's what this video's from.
Has it been changed or altered in any way?
No, it doesn't look like it.
All right, ma'am, go ahead and hit play for us. And as things are happening, can you go ahead and describe what Mr. Jones is doing?
Sure. You see, at this point, he's riding a motorcycle off a ramp. It was one we built on the mountain, and then he lets go of the motorcycle, and then 4 seconds in, we give him the signal, and he pulls his parachute to land safely on the ground.
Who was responsible for giving him that signal?
Well, that day, it was that producer I mentioned, Cole.
Thank you.
Objection, Your Honor, to lack of foundation, specifically to that last response about who is responsible.
All right, counsel.
Your Honor, this witness has talked about being present for all the interactions happening between Mr. Jones, the control of the area, being present with the control room as these things were happening. She has the foundation to testify to who was giving the signal and who was responsible for that.
Well, perhaps she does if you ask the right questions.
Certainly, Your
So,
Honor.
objection sustained.
Yes, Your Honor.
Ma'am, were you present during the time that these stunts were happening?
Yes, I was. I would be in the control room with the producer and the rest of the crew.
And could you see who was giving the signal to Mr. Jones?
Yes, around those 4 second mark what I mentioned. That's when the producer would yell into Peter's earbud that it was time to pull his parachute.
Permission to approach and grab that exhibit, Your Honor.
Yes.
Ma'am, then I want to just go ahead and talk a little bit more about that stunt that happened on June 20th, okay?
Of course.
Ma'am, how'd that day go for you?
Well, on June 20th, that was the first day we were supposed to actually film the stunt. And so Peter got on his bike and we started running through the stunts.
Was it successful on that day?
It was. On that day, it was successful. We did the stunt 6 times and there were no issues.
So if you got the stunt 6 different times, were you finished filming on June 20th?
Well, I mean, we thought so. But, well, that night we had a big dinner. We were supposed to celebrate finishing the movie and all, but at that point, that producer pulls me and Peter aside and tells us that he wants to keep filming. He wants to do the stunt again.
Did he say why?
Yeah, I mean, he said that he was looking over the footage from that day and he just didn't think it was long enough. He thought it wasn't good enough.
And I want to talk about what might have made June 21st different than June 20th when those stunts were successful.
Sure.
Did the director of this company explain to you whether or not that stunt was going to change?
Well, yeah. You see, the producer wanted Peter to be in the air for twice as long. Instead of calling it at 4 seconds, he was going to call it at 9 seconds. But he promised that at 9 seconds he would call and tell Peter to pull his parachute.
So when Mr. Jones actually proceeded to do the stunt on June 21st, was it a different one that had been originally planned?
It was. It was supposed to be longer than we'd planned.
So we talked about the stunt. Let's talk about whether there were any differences with the staff.
Sure.
Ma'am, on June 20th, when these stunts were successful, do you happen to remember whether the team was around Mr. Jones?
Yes, the crew was there on June 20th.
Were you also in the control room?
I was. On both days, I was in the control room.
Were other members of the team there?
On June 20th, they were.
Did you and Mr. Jones work with anyone in particular to help create a plan for that day?
Yes, we worked with a stunt coordinator. She was a real nice lady. She helped us coordinate all the stunts and make sure they were going to be safe.
Was that person who helped you coordinate all those stunts there on June 20th?
Yes, on June 20th, she was there.
What about the 21st, ma'am? Were there any changes in the staff that was present?
Well, actually, yeah. I mean, since filming was supposed to wrap up on the 20th, the stunt coordinator, Scott, she went home. So she wasn't there on the 21st.
And I want to move on and talk about that signal you mentioned. Ma'am, on June 20th, who was giving that signal to Mr. Jones about when he should open his parachute?
Well, it was just me and the producer Cole in the control room, and Cole said that he was going to be the one to give the signal.
Was he the only other staff person who was in the room?
Yeah, it was just us two in the control room.
Ma'am, on June 20th, were they able to successfully give those instructions, make those calls?
You know, I mean, I thought that's what was going to happen. You know, I thought that once Peter went off the ramp, you know, just like those other times, he was going to make that call. He was going to tell Peter when to pull his parachute, but he didn't.
Ma'am, are you saying on that June 21st day, the director never made that call?
No. No, he promised us he would. He promised he'd keep Peter safe. I mean, I've been working with Peter for 11 years. And we trusted him.
Did you say anything to this director as Peter was going off the ramp?
Of course I did. I mean, 8 seconds go by, 9 seconds, I'm looking at the same monitor he is, and I tell him, why aren't you telling him to pull the parachute? And he just stands there, he puts a hand in my face, and he doesn't say a word.
Do you know what happened to Mr. Jones after this defendant failed to give him that signal?
Yeah. Never forget it. 15 seconds go by and finally, Peter on his own, he pulls his own parachute. He realizes, something's wrong, I guess, and that's when, it's too late. It hits the ground and the crew that's in the air, I guess he was dead, but I don't want to believe it,
Ma'am, when you saw this director with Mr. Jones's body, did he say anything to you?
Yeah, I mean, I asked him. How could you do this? Why'd you wait? And he looked at me and he said, I wanted a longer shot.
Thank you for your time today, ma'am. Your Honor, I have no further questions at this time.
All right. Any cross-examination?
Yes, Your Honor.
You may proceed.
Good afternoon, Ms. Goodwin. I'm so sorry for your loss. We'll just ask a few questions and send you on your way.
Thank you, ma'am.
You told us on direct examination that Cole Doig never gave the signal that day?
That's right. I was in the control room and he never made it.
You were the only other person in that control room with him?
That's right. I mean, the stunt coordinator wasn't even there that day.
That's right. So that stunt coordinator nor anybody else could corroborate what you're telling us in court.
Well, no.
Objection, Your Honor, to lack of personal knowledge.
Response? Your Honor, the witness just testified that she was the only other person in the room that day. She would be able to answer whether or not anyone could corroborate her story. Further, this is cross-examination. If she doesn't know, she can say so.
Response, Your Honor.
Go ahead.
Your Honor, she's not privy to whether or not there are any other ways for people to have gotten information from the sound going on in that room. She couldn't possibly testify as to whether other people can corroborate those events.
All right. The objection's overruled. You may proceed.
Ma'am, because you were alone with Cole Doig in that control room, nobody else can corroborate the story you're telling us today.
I mean, I'm sure you could ask him, but he didn't make that signal.
Okay, we'll do that. Now, Mr. Jones, he also talked to you about the staff that was present that day, so I want to make something clear. Now, that stunt coordinator, she wasn't the one who was pulling the strings of the parachute during the stunt, was she?
No, that was Peter.
You weren't the one pulling the strings of the parachute that day, were you?
No, that was Peter who was up there supposed to pull the cord, and we were supposed to let him know when to do that.
That's right, ma'am. It was up to Peter to decide when to pull the strings of his parachute. Yes?
Not quite, ma'am. He wouldn't know when to do it on his own. We actually needed to signal to him from the control room when it was the right time.
Well, I want to talk about whether or not Peter Jones might have been making decisions for other reasons. You'd agree with me, he's the biggest movie star in the whole world, right?
That's right. I mean, everybody loved Peter. He was the nicest guy.
He was specifically known for his success in the All Lost movie series, right?
That's right. That was the movie that made him his big name,
And those movies, they featured unbelievable stunts, right?
Yeah, and every one, they plan out a different stunt, and we worked with that same stunt coordinator, Scott Stebbins.
And his movies and those stunts, well, they were pretty successful, weren't they?
Absolutely. I worked with him on every single one of them.
His movies and those stunts, they grossed over $5 billion in revenue, didn't they?
That sounds about right, yeah.
That's a lot of pressure for Mr. Jones, isn't it?
Objection, Your Honor, just speculation.
Counsel.
Your Honor, this is cross-examination. If she doesn't agree that a $5 billion movie plan was not a lot of pressure for Mr. Jones to perform, then she can say that she doesn't.
Response, Your Honor.
Go ahead.
Your Honor, whether or not the money played an impact on how much pressure Mr. Jones was feeling would require this witness to delve into her mindset. She can't speculate to those facts.
All right, overruled. You can
Sure.
proceed.
Ms. Goyan, you specifically put a lot of pressure on Peter Jones to perform in those movies, didn't you?
No, I mean, Peter loved his job, and I mean, he was always willing to do another.
Well, you worked together for every single movie that he performed in, right?
Of course, but the pressure, I mean, there wasn't any pressure on him.
Well, you yourself, you were making tens of millions of dollars from these movies, weren't you?
Yeah, I mean, we worked together on him. I got 5% of whatever Peter made.
And his success in those movies, well, it was based on his dangerous decision-making, wasn't it?
I mean, it was based on the stunts and, you know, the plan that we made to make sure that they were safe.
You'd recognize some pictures of Mr. Jones's previous stunts if I showed them to you.
Sure, yeah.
Ma'am, you have a binder in front of you. If you could flip through exhibits 26 through 30 and just let me know when you've looked at them all.
I've looked through them, yeah.
Those are the pictures from Peter Jones's previous stunts in his previous movies.
Yes, that's what they look like.
The pictures appear to be fair and accurate.
They do.
Your Honor, defense moves to admit exhibits 26 through 30 into evidence.
All right. Counsel for plaintiff?
No objection to the pictures, Your Honor.
All right, they'll be admitted.
Your Honor, permission to publish a copy of the pictures to the members of the jury?
Yes, go ahead.
There's a lot of them. I'll give them to you to pass them. Ma'am, I want to go through these stunts one by one. Now here in Exhibit 26, we have Peter Jones hanging from a mountain 5,000 feet off the ground, right?
Yeah, that's right. That was in one of the earlier movies.
And here in 27, we have him rappelling down the world's tallest building.
That's right. That was the stunt we'd planned.
In 28, we have him hanging off an airplane after it left the ground.
That's right.
In 29, well, that's when Peter Jones decided he was going to hold his breath underwater for several minutes at a time.
Well, you see, Peter would come up with the stunts, but we always had a stunt coordinator to decide what was safe. So the stunt coordinator helped us decide how long he could stay underwater.
Like you just said, Peter was the one coming up with these stunts.
He'd come up with the idea, and then we'd get the right crew in place to put it together.
Well, I want to talk about the other decisions he was making. Because you'd agree, he never used a stunt double.
No.
He never asked that you use computer-generated images during the stunts, right?
No.
Peter insisted that he do all of them on his own.
Yeah, I mean, that was part of his contract for this movie.
But Peter told you he wanted to do stunts that no other actor could pull off, right?
That's right. I mean, Peter would go under a lot of training. He became an expert in skydiving.
And I want to talk about what else was influencing his choices. Because you'd agree with me, Peter told you that he had a specific reputation, right?
Yes, that's right.
He called it a do anything for the audience reputation, yes?
Yeah, he liked that his audience liked him for the things he did.
He told you exactly what he needed to do to uphold his precious reputation, right?
I'm not sure what you mean, ma'am.
Peter Jones once said, Travis Harper is the kind of character who doesn't do anything.
Objection to hearsay.
Counsel?
Yes, Your Honor. Peter Jones is our party opponent in today's case. He is the plaintiff. So pursuant to 801D2, his statements aren't hearsay.
Counsel?
Your Honor, that doesn't swing both ways. We can offer those statements. Opposing counsel cannot.
Your Honor, if I may respond,
Yes.
we represent the defendant in today's case. The plaintiff is our party opponent, not Mr. Jones, so 801D2 actually only applies to us in this case with regards to Peter Jones's statements.
All right. So you're half right, it sounds like.
Yes, Your Honor.
Anything further you want to say?
No, Your Honor.
Okay, overruled.
Peter Jones told you that Travis Harper is the kind of character who doesn't do anything halfway.
Yeah, I mean, that was the character he was playing in the movie.
And I want to talk about why that quote was just so important for today's case. You'd agree with me that on June 21st, 2023, Peter Jones was pulling the strings that day, right?
If you mean the parachute, yeah, he was going to pull the parachute when we told him it was time.
I actually don't just mean the parachute, so let's talk about the other strings that he was pulling. You'd agree with me it was a motorcycle stunt, yes?
Yes, that's right. Like the one in that video I talked about.
And that stunt was Peter's idea.
Yeah, the idea was his.
You'd agree with me you didn't use computer-generated images during the motorcycle stunt.
No, we used a little CGI to edit out some clouds, I think, but that was all.
Peter never asked you to use any extra CGI to help him do the stunt properly.
No.
He never used a stunt double in that motorcycle stunt.
No, that wasn't necessary. Peter became an expert in skydiving, like I said.
But let's be clear. Peter Jones decided that he didn't want to use a stunt double, right?
That's right, and that was what was in his contract, too.
Thank you for your time. Nothing further, Your Honor.
All right, thank you very much. Anything further for plaintiff at this
Just a
time?
time check before I decide on that.
12 seconds.
You direct, Your Honor?
If you can do it in 12 seconds.
May I proceed? Ms. Zedell asked you about the defendant role in these stunts. Ma'am, did Mr. Jones rely on the defendant at all on June 21st?
Absolutely. They were supposed to give the signal.
Did they?
No.
No further questions, Your Honor.
All right, thank you very much. Anything further from plaintiff at this time?
No, my apologies, Your Honor. No, Your Honor, and barring any recross, with your permission, the witness can step down.
All right, thank you.
We have no recross.
All right, thank you very much. Thank you very much.
Thank you.
And at this time, Your Honor, we'd rest our case in chief.
All right, thank you very much. Counsel for Dragon, you may proceed.
Yes, Your Honor. Defense calls Cole Doig to the stand.
All right.
Good afternoon. Please introduce yourself.
Hi, I'm Cole Doig.
Do you know why you're here in court today?
I do. I was the producer of All Lost 7, the film where Peter Jones was killed.
We've heard a lot about Mr. Jones today, so I want to ask, who was Peter to you?
Peter was a good guy. You know, we met on the set for the first time when we were shooting the first scene for All Lost 1. I mean, I really couldn't have imagined what came from that. I mean, multinational success, billions of dollars. I mean, he was the biggest actor in North America. He's a legend.
You mentioned that you worked with him on All Lost 1. Mr. Doig, did you work with Peter Jones throughout the entire All Lost series?
I did. I produced all 6 movies and was producing the 7th. It was me and Peter.
Did all of those movies feature any stunts?
Oh, yeah. No, I mean, that was the point. All loss. I mean, we went all in. We, set up drones. We're having them cling onto planes, jump off ships. I mean, Peter would name it, we'd do it. He pulled off the impossible.
You're telling us that Peter pulled off the impossible. I want to delve into that just a little bit more.
Sure.
Now, during all of these stunts, who came up with most of the ideas?
Well, I played a role in writing the films, but Peter would always come to me with the stunts. I don't think you could try and find a more imaginative guy if you could. He'd come and pitch otherworldly ideas, and then we look into them and see if we could pull them off.
Did he ever use stunt doubles?
No. Peter would resent the accusation. Never happened.
Did he ever ask you to use CGI to replace any of the aspects of the stunt?
No, unless there was a glare on his glasses that I couldn't see his face. No. Peter wanted everything legit. See him on the screen, you knew he was doing it. He earned the reputation he got.
Now I want to transition and talk about the stunt that he was performing on June 21st of 2023. Could you tell us a little bit about what that was?
Sure. That was the stunt where Peter actually came to me and said he wanted to drive a motorcycle off a mountaintop. There was this big action scene, and instead of jumping away or anything like that, he wanted to drive that motorcycle right off a mountain. It was the biggest stunt we'd done yet. So, we pitched it, we had the safety people look at it, and ultimately we decided to go ahead with it.
Well, you're telling us you had the safety people look at it. So with regards to the original plan for the stunt, what were the safety specifications?
We really did everything we could there. We hired a safety professional, Skye Stebbins. She's the best in the business. She would come in, she'd look at the air, the trajectory in which the fall would be coming in. I mean, we'd used her since All Lost 2. I mean, she's brilliant. We had calculations, papers. Peter would know what angle to dive at. Everything.
Before we talk about those calculations, I want to talk about whether or not your staff stuck to their original plan.
Yeah.
So with regards to the original motorcycle stunt, how long was Peter supposed to be in the air?
In the air, free falling, about 4 seconds before he was going to pull that parachute line, and then he'd float down to safety.
On June 21st, 2023, did you follow that plan, the 4 seconds?
No. We actually changed that plan the day before. We decided to add some more time there and go to 9 seconds.
Did Peter agree to those changes?
Absolutely. I pitched the idea to Peter. We looked at the math. And no, we both decided to go ahead with it. I talked to Miss Stebbins, and we were good to go.
You mentioned that you looked at the map.
Yeah.
I want to talk a little bit more about that.
Sure.
Mr. Doy, you have a binder in front of you. If you could flip to
Do.
exhibits 14 and 15. Your Honor, these are pre-admitted.
I'm there.
I want to talk about these one by one.
Sure.
What are we looking at here in exhibit 14?
So this is the angle that Peter was going to come off the ramp we built. The little CGI we did here, nothing to do with Peter. We just made that ramp the mountaintop. And then he'd actually jump off once that motorcycle came off that ramp. You see that little box there? That shows the position the motorcycle was at, and then Peter right on top.
And exhibit 15, what are we looking at here?
15. This is the actual math we did. So we had the calculation for how fast Peter would fall through the air. So we knew exactly when he'd have to pull that parachute, float to safety.
Your Honor, at this time, I'd like to read a portion of Sky Stebbins' deposition, that stunt coordinator, onto the record.
All right, any objection?
Just ask what our counsel's reading from so we can read it beforehand.
Lines 113 through 115.
All right.
Question, can a skydiver survive if their parachute isn't fully inflated until 1,000 feet above ground level? Answer, if your parachute is open and fully inflated by 1,000 feet above ground level, that's technically enough time to slow down and land safely.
You'd object to that portion of testimony under 702?
Counsel.
Yes, Your Honor, we're not offering this for an expert opinion. 702 wouldn't apply. Mr. Doy told us that he relied on the stunt coordinator's calculations in this case. We're just providing some context for the members of the jury about where those calculations came from and why they're important.
Response, Your Honor?
Go ahead.
Your Honor, what counsel just read onto the record is an expert opinion about whether or not diving at 1,000 feet was technically safe or not. We have no foundation about whether Sarah Stebbins applied a method, reliably applied that method to determine that conclusion, and it certainly doesn't get to what was told to Mr. Doy. They can certainly ask those questions, but offering this portion of the deposition is a violation of 702.
All right, any reply?
Yes, Your Honor, we're not offering this for an expert opinion, and we're fine with a limiting instruction to that effect. We know for a fact that Cole Doy, Peter Jones, worked with this stunt coordinator in coming up with the plans for the safety of the event. We're simply laying the foundation and creating that context for why the plans were made the way they did. We don't need to offer this as an expert opinion.
All right, counsel, if there's a limiting, Mr. Jones, if there's a limiting instruction that advises the jury that this was information that was provided, but not necessarily an expert opinion as to what in fact was safe, is that sufficient to satisfy your objection?
No, Your Honors, because the portion of the deposition talks about whether or not it was technically safe. If they'd like to ask this witness what was communicated to him, they can certainly do so. But offering this testimony about what was technically safe violates 702, and that limiting instruction wouldn't be enough.
All right, I'll take that under advisement in terms of how I will instruct the jury with respect to the portion of the deposition that's been read.
Yes, Your Honor.
Both of you may proceed.
Your Honor, just a point of order. As of now, is the deposition still on the record?
It's on the record, and how I instruct the jury about how they should treat it, I'll let you know before we send the jury out for deliberations.
Yes, Your Honor.
Sounds good, Your Honor. Now, Mr. Doy, according to the calculations on Exhibit 15, at what time would Peter Jones's body reach 1,000 feet above ground level?
He would hit 1,000 feet about 13 seconds after he jumped.
And in your experience practicing these stunts with him, do you know how long it took for Peter Jones's parachute to inflate once he pulled the strings?
It would take about 3 seconds. That's what Miss Stebbins told us before the actual stunt we tried, and in practice when it happened before it. It was 3 seconds as well.
So, if you wanted to make sure that his parachute was fully inflated by the time he hit 1,000 feet above ground level, well, when would you need to signal him to pull the strings?
About 9 seconds. It took about a second for Peter to react. We wanted to budget in some time there so we could pull his arms, pull the string, and float to safety. That 9-second number is actually what we ended up going forward with.
That brings us to our next point, Mr. Doyle. On June 21st, 2023, did you tell Peter Jones to pull the strings at 9 seconds?
I did.
Did he pull them?
No. I was in the control room that day. I had my radio in hand, and I was watching the clock as Peter went on that ramp and jumped. He was going through the air. I saw time pass, 3 seconds, 6 seconds. And at 9 seconds, I hit the button and said the word. I told him to pull.
Did he?
No, I don't know what happened. I kept saying pull, pull. 9 seconds past 12. I don't think he pulled until about 15 seconds after he jumped.
And then what happened?
It was too late. I mean, we knew going in he had to pull that string on his back at 9 seconds. It was the only way he'd have enough time to float down to safety. When I saw his body go to the ground, and even up there, I knew what happened.
Mr. Doyle, is there anything you would have done differently that day?
No. I mean, we did what we set out to do. I mean, we had the plan in place. I said the word in 9 seconds. I mean, everything should have been fine. I don't know why he didn't pull the string, but he didn't. And I'll always wish he did.
Thank you for your time, Mr. Doyle. Your Honor, I have nothing further.
All right, thank you. Cross-examination?
Yes, Your Honor. May I proceed?
Yes, go ahead.
Sir, you just swore under oath that your safety instructor told you it was safe to do that stunt the way you did on June 21st, right?
Yes, sir. I spoke to Miss Stebbins. She gave us the go-ahead.
Your Honor, reading from a portion of Ms. Stebbins' sworn deposition, starting in line 164. Before you left, question. Before you left, did you discuss the possibility of doing an additional take of the stunt? Answer. Yes, on June 20th, before the group dinner, Cole Doyd pulled me aside. Doyd asked me if I thought we could do one more take of that motorcycle stunt on June 21st. Except this time, Doyd would delay giving the signal until Peter had been in the air 9 seconds. He said, I used your numbers, worked it out. If I give the signal at 9 seconds, the parachute will be inflated by 13 seconds. Peter's still above 1,000 feet. That's still safe. Question. How'd you respond? Answer. I said, no way. That's cutting it too close, especially when I'm not there. Sir, you made some promises to Mr. Jones about how you would keep him safe, right?
Absolutely. You know, going into that shoot, we had to take steps to ensure his safety.
In that conversation you just spoke with us about, when you were telling him this idea, you told him our stunt coordinator cleared it.
Yes, Miss Stebbins did clear that stunt. I spoke to her before the dinner. She said it was okay. I'm not sure how you got her to say that. I don't know why she would.
Sir, you just heard that was a sworn deposition, right?
Sir, I don't know why Miss Stebbins lied. I got the go-ahead.
So what you're telling us is that your safety coordinator lied in a sworn deposition. That's your testimony.
Yes, sir. I don't know why she did it. Whether or not that's covering her company, I guess we shouldn't deal with outside contractors, but no, sir. That's not the truth.
So bringing you back to my question, that's a yes, right?
Sir, that was untrue.
Well, let's focus a little bit more on you. Because, sir, like we talked about, you made some promises about how you were going to keep Mr. Jones safe.
Absolutely. We promised to give the word in 9 seconds, and that would be that.
You promised to create a safe environment for him.
Yes, and
You
that's
promised
exactly
to
what we
stick-
did.
My apologies, sir. Go ahead.
I said yes, and that's what we did.
You promised to stick to a safety plan.
Yes. No, everything we had Peter do, we put it in writing, or we told it to him in his face, and that's what we did.
Sir, you promised you wouldn't expose him to any kind of unreasonable harm, right?
No unreasonable harm he didn't know about. He knew about the shot and exactly the steps we'd take.
Sir, I want you to look at some of those pictures Mrs. Zedell just spoke with you about. Go ahead and flip
Sure.
in that binder to Exhibit 26.
26.
So that's one of the stunts Mr. Jones did, right?
Yeah, we shot in Utah. This is him hanging off a cliff here.
For that stunt, he relied on your team, didn't he?
He did. He did it with his bare hand.
Flip to the next one, sir. That's another stunt Mr. Jones did with your company, isn't it?
Yes, sir. This is Peter scaling the Burj Khalifa again. No harness.
Once again, he relied on your company, right?
Absolutely. We took steps to make him safe. That's why we hired Miss Stebbins.
Sir, just like June 20th, Mr. Jones, he was relying on your company, right?
Well, we hired Miss Stebbins. That was a separate company, but yes, we hired people to keep Peter safe. That's what we did.
So that's a yes to my question. Mr. Jones was relying on your company for this stunt on June 20th, right?
Yes, in some ways, and we relied on other companies too. There were multiple players here.
You said in some ways. I want to talk about what you might mean, because what you mean when you say that, sir, is giving the signal for him to open up his parachute, right?
Objection, Your Honor. Argumentative, specifically to what you mean at the prefix of that sentence.
Response, Your Honor?
Do you have something to say other than it's cross-examination?
No, Your Honor, that's exactly what I was going to say.
All right, it's cross-examination.
Yes, Your Honor.
All right, thank you.
Sir, you said some people were responsible. What you mean when you say that is that you, personally, were responsible for giving Mr. Jones the signal he needed to open up his parachute, right?
I mean, sir, that's obviously not the only step we took to ensure Peter's safety, but that was my job in that control room, and it's exactly what I did.
Sir, that's a yes to my question, right? It was your job to give him that signal, correct?
Yes, sir.
You were the only person who had that responsibility on your team, right?
That's true.
And you know you didn't give Mr. Jones any kind of other device so he could track it himself, right?
That's right. We came up with the plan. The plan was the earphone in his ear, and I give him the word.
So then let's talk about why that day might have been different. Because like you just told us when you were speaking with counsel, you changed the stunt, right?
Yeah, Peter and I both agreed to change the stunt. We were going to make the shot a little bit longer, get more film there.
You wanted him to spend more time in the air, right?
Yes, we had the free fall, and then he was going to pull the parachute at 10 seconds.
So that's a yes. You wanted him to spend more time in the air.
Well, actually, it would be less time in the air overall. He would free fall and then pull the parachute.
You extended the time between when you gave him the signal on June 20th to when you gave him the signal on June 21st. That's true, right?
That's true, yes.
So you changed the stunt. Your staff, sir, that was different too, wasn't it?
Yes, so we'd had a lot of staff there the first day. That was originally when we planned to do the whole shoot. For the second day, a number of people had gone home.
Sir, just a yes or no will suffice, and that's a yes, right?
Yes, that's how the staff changed. Sir.
It was a big team, wasn't it?
Yes, it was.
You had people on the ground with Peter.
We did.
You had people in the control room.
Yes,
You had people working with you inside the control room, right?
that is true. Yes.
You had a stunt coordinator there, right?
Yes, Miss Stebbins, who I had mentioned earlier.
The person who had crafted that stunt to make sure it was safe.
Yes, Miss Stebbins actually left the next day. She went home, but she was there on the 20th.
That's right, sir. On June 20th, she was there. On June 21st, she was not. Right.
That's true. She gave us the go-ahead and flew home.
She couldn't tell you about if anything you were doing on the 21st was safe, right?
No, that's not right, sir.
So she wasn't physically present with you to see what you were doing that day, right?
No, sir, that's why we discussed it the day before.
Then let's talk about that signal. Because, sir, on June 20th, you gave that signal, right?
I did, 6 times.
You were here when Miss Gouglion testified, weren't you?
Objection,
no.
Your Honor, pursuant to Rule 615. Can I be heard?
Yes.
During pretrial, we invoked Rule 615, and we made the court aware that we weren't having any party representatives. Because of that, Mr. Doig was sequestered during Ms. Gogion's testimony, so it wouldn't be fair for Mr. Jones to cross-examine him about it.
That wasn't my actual understanding, Your Honor. It was my understanding that Mr. Doig was their party representative. We didn't have a party representative.
Well, all right. Counsel did say that there was no party representative for the defendants.
Certainly, Your Honor.
All right. So, sustained, why don't you
Yes, Your Honor.
rephrase the question? You may be able to get to the same.
Certainly, Your Honor.
All right.
Sir, on June 20th, you gave that signal successfully, right?
I did, 6 times.
And Mr. Jones, he was able to deploy his parachute 6 different times on that day.
That's true.
But on June 21st, something was different, right?
Yeah, when I gave the signal, he didn't pull the string.
You're claiming you gave that signal, but sir, this was the only time during all your practices that Mr. Jones pulled it late, right?
That's true. I really don't know what went wrong.
So the truth about that day is that you changed the stunt before it ever happened. Isn't that right?
The plan for the stunt?
Exactly, sir. It was different from June 20th to June 21st because of what you decided to do, right?
I didn't decide it alone. It was a decision I made with Peter, Miss Stebbins. We made that decision together.
That's a yes.
No, I didn't make that decision alone. That's not true.
You decided to change the
Counsel,
plan, right?
Counsel.
Time has elapsed at this point.
All right. Thank you very much.
Yes, Your Honor. Thank you.
Redirect,
Why don't we check your time?
of course.
26 seconds.
All right.
I'll be brief.
All right. Yes, you will. Go ahead.
Mr. Jones just asked you about whether or not Peter Jones relied on your company during all of the stunts that he performed, so I have to ask, who made the decision to do all of those stunts himself?
Peter did. I mean, Peter pitched the stunt and refused any stunt doubles. At the end of the day, every single stunt Peter did was his call.
Thank you for your time. Your Honor, I have nothing further, and barring any recross, we'd ask that the witness be excused.
All right.
Circumstances don't allow, so no recross, Your Honor.
All right. Thank you. You are excused.
Thank you.
Thank you very much.
With that, Your Honor, the defense rests.
All right, it's time for closing argument. Counsel, why don't you each take a minute to gather your thoughts, and then we'll have closing argument. All right, Mr. Jones, whenever you're ready.
May I proceed?
Please.
Their decisions made that day different. There's a moment in this trial that I want you to remember. It's when I was cross-examining Mr. Doig, who represents that studio. When I was asking him about why he decided to change this stunt. He said, I just wanted that longer shot. He put getting that longer shot over Mr. Jones's life. And you know that today because you heard from a witness that swore he never gave him that signal. You learned today that it was their decisions that put Mr. Jones at risk, their decisions that made that day, different from all the rest. Members of the jury, I told you at the beginning of this trial, this case would come down to that one key question. What made that day different? And so I want to ask you that question today and look at it in context with the evidence. Because today we've shown that it was their decisions, and those decisions were negligent. Their decision to change the stunt, their decision to change the staff, and their decision not to give him his signal. Members of the jury, I want to take you through those one at a time to show you how we met our burden. Starting with that first thing, the stunt. Because today you found out that there was an agreed upon plan between Mr. Jones and this defendant company. He was going to be in the air for 4 seconds. He was going to get the call, and he was going to parachute safely onto the ground. That was the plan. And then this defendant's company, they weren't satisfied. You heard that Mr. Doig, he walked up to Mr. Jones and said, "It's just not good enough yet. It's not compelling yet." So what did they do? They decided to extend the amount of time that Mr. Jones was in the air, and that was not a safe decision. They changed the stunt. That takes us to part number 2. They changed the staff. Because today you heard, members of the jury, that on June 20th, this defendant company, they had a full team behind Mr. Jones. They had people working with him on the ground. They had people working with him in the control room. People monitoring his every movement. People who knew where he was at in the air. They had a team. June 21st. This defendant has a director. And no one else. No one else who's looking out for Mr. Jones. No one else who can hold this director accountable. Critically, members of the jury, the person who they relied upon to make sure that this stunt was done safely, that coordinator, she wasn't there either. Changing the staff was a dangerous decision. Takes us to part number 3. The signal. Because today what you heard, members of the jury, from when Ms. Guglion testified, she told you that she was standing in that control room alongside Mr. Doig. She told you that she waited and waited and waited until it was too late to make the call for Mr. Jones. She told you that she never gave him the signal him to open his parachute. They changed the signal. All of those decisions, members of the jury, when you put them together, they add up to negligence. They add up to this defendant company not caring for Mr. Jones. They add up to this defendant company not acting like a reasonable employer should. Today, you've learned that their decisions were dangerous. But that's not the only question you have in front of you today. When Ms. Zedell gets up here, I expect she's going to talk to you about something called comparative liability. She's going to ask you to determine whether Mr. Jones was at fault for his own death. So I want you to consider the evidence that you have towards that. Because on June 20th, when Mr. Jones was practicing this stunt over and over again, he was the exact same person they're claiming he was today. So why not on any of those other practice runs where he's doing this exact same thing, did it fail? Why not on those other runs was he trying to push the limits? Why not on those other runs? Doesn't make sense. Because that's not what made that day different. It was their decisions. Their decision to remove the staff. Their decision to change the stunt, and their decision not to give him that signal. Those decisions were dangerous. That's why at the end of this trial, I'll stand up here again. I'll ask you to find this defendant liable for negligence. Thank you for your time.
All right. Thank you, Mr. Jones. Ms. Zedell?
Yes, Your Honor, may I proceed?
Please.
Mr. Jones, members of the jury, may it please the court. He was the one who was pulling the strings. While flying midair, 2,700 feet off the ground, Peter Jones had just one thing on his mind: his reputation. He was filming another multi-million-dollar movie, so when his motorcycle left the cliff in June of last year, of course he was concerned with how it looked. Would his fans be impressed? Would his studio produce another hit? It was those thoughts, those concerns that led Peter Jones to ignore the instructions of the director that day. He was pulling the strings. He pulled them too late, and that's what killed him. None of this should have happened. But when tragedy strikes, we have to remember that there's a trap that we as humans should avoid falling into. It's the urgent need to find somebody, anybody, to blame. And it's exactly what's happening to Peter Jones's family. That's why we're here in court today. Not because my client is actually responsible, but because a wife lost her husband. Children lost their father. But I want to remind you that you can't bring justice to Peter Jones's family if the decision that you make is unjust. That's why we've raised an affirmative defense today and assumed a burden of our own. We've shown that it was Peter Jones' own negligent decisions that unfortunately caused his death. He was the one pulling the strings that day. It's not easy to ask this of you. We get that. But it's your job today, your responsibility, to look past the emotion and examine the facts of this case under the law. It's the same law that required the plaintiff to prove their case by the preponderance of the evidence. They walked through those doors with a burden to bring you evidence, to show that it was only Dragon Studios' decisions, only theirs, that could have possibly caused Peter Jones' death. Mr. Jones, he wants you to believe that it was their decision to change the stunt, their decision to let the staff go and take another shot, or their decision to change the signal from 4 seconds to 9 seconds. Members of the jury, none of that actually matters. This case comes down to one moment when Peter Jones was in the air and he made a decision, a reckless decision to ignore the signal that he was getting from his director and pull the strings a few seconds too late. Those were his decisions, and his decisions were the ones that made the difference. Mr. Jones told you that, well, Mr. Doig, he didn't actually give the signal. But at that point, you're really left with a he said, she said at best. And if you don't know, if you're unsure of who you want to believe, Ms. Gogion or Mr. Doig, well then the plaintiff has failed to meet their burden today. And if you agree with that, well then we're done here, case closed. We get to go home and you have to find my client not liable. But if you do think that the plaintiff has met their burden, well then you have a few more questions to consider. What about Peter Jones's decisions? Who was actually pulling the strings that day? And with those questions in mind, I want to remind you of the 3 choices that I talked about during opening statements. The 3 choices Peter Jones made. 1, he chose the stunts. 2, he chose not to have a stunt double. And 3, he chose to ignore the instructions of his director and failed to pull the strings of his chute after 9 seconds. Let's go through these choices one by one. After we're done, it'll be clear that it was Peter Jones's own negligent decisions that unfortunately caused his death. Choice 1, the stunt selection. Neither side would dispute that Peter Jones was a daredevil. I mean, you heard in court today, he put himself in extremely dangerous situations all of the time. Every single stunt being more dangerous than the last. I mean, I asked the plaintiff's own witness, and she told you herself. Hanging from a mountain 5,000 feet in the air, rappelling down the world's tallest building, holding his breath underwater for 6 minutes, and jumping out of a plane after an electrical storm. Members of the jury, it's obvious. Peter Jones was willing to put his life on the line for the sake of his success. That's dangerous, that's reckless, and that's negligence. So choice 2. He never used a stunt double. Don't you find that interesting? The actor, the star himself, the face of all of these movies opted not to use a stunt double? Members of the jury, that's not something we see every day. Stunt doubles are people trained for situations like these. Production studios hire them to avoid trials like the one we're all sitting in right now. Peter Jones could have had one. He could have been safe, but he made the decision not to. He was pulling the strings. And choice number 3, he didn't listen. There's no question that the most dangerous decision Peter Jones made was when he was flying through the air on June 21st, 2023. After Cole Doig told you, he yelled, "Pull, deploy." Well, Peter Jones waited a few extra seconds before he pulled the string of that parachute, and it was those few seconds that killed him. You know exactly why. This was a map that planned Peter's trajectory through the air that day, and you saw that he would reach 1,000 feet at 13.3 seconds. You see, my client, they made the calculations. They found out that 1,000 feet was the minimum safe altitude at which he would need to pull those strings, and Peter Jones, he knew that. He got the signal, but he ignored it, and that's where the responsibility of my client came in. Because he learned that Mr. Doig, he gave that signal, but he wasn't in the parachute. He wasn't pulling the strings. That was on Peter and Peter alone. There's no question that any tragedy, especially a death of somebody so loved, is devastating. Peter Jones's family is going through an unimaginable loss. But an unimaginable loss isn't made better by throwing blame at the easiest target. It is made better if we can make sure that our actors, daredevil or not, start putting safety before their reputations. An unimaginable loss is made better if we can make sure that the next person pulling the strings of their own life chooses to do so safely. So I'd ask that you help us get there and find my client now alive. Thank you for your time.
All right, counsel for plaintiff.
May I get a brief time check?
1 minute.
Thank you.
All right.
May I approach the jury and grab some documents?
Sure.
May I proceed?
Please.
There was one string Mr. Jones was never responsible for pulling. The string to let him know when to open that parachute. And you know it's consistent with every other stunt he's done. Because I asked their witness, did he rely on you for this stunt? Yeah, he did. Did he rely on you for this stunt? Yes, he did. Did he rely on you for this stunt? Yes, he did. Did he rely on you for this stunt? Yes, he did, and the exact same thing is true about June 21st. So what was different? This defendant, deciding that the stunt wasn't good enough. This defendant, deciding that they don't need an entire team to make sure this is safe. And this defendant deciding, I can wait just a little bit longer to give that signal to Mr. Jones. Their decisions made that day different. Find them liable. Thank you for your time.
Thank you, counsel. I've now instructed the jury, making a difficult decision about the Rule 702 objection and the limiting instruction. We'll give the jury a moment or two to figure out what they're going to do. And then when they have completed, I'm going to ask each of them to provide a single comment to each of the counsel, if they would, but just one. And